Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. 2 more documents were published on the court docket that, in my opinion, just seems to go to the unparalleled secrecy of the case that has existed since the beginning of the case. If you look on the case summary page, maintained by the clerk of court, to document all of the key events in Idaho versus Kohberger, such as the filings by the parties, motions, responses, replies, court orders, notices of hearings, stipulations, which are agreements between the parties, documents that have been filed in support of the parties' various filings, such as declarations or other matters. You will see just how many documents have been filed under seal. On top of the filings that were filed under seal, there has been a gag order, a non-dissemination order of some kind or another. It's been amended a few times since the first non-dissemination order was entered on the parties' motion. The parties both wanted this non-dissemination order put into place. They filed a motion for that non-dissemination order together back on January 3rd, 2023. And the first non-dissemination order was entered that day. That is the reason why, unlike in many other cases, particularly high-profile cases like this one, you will on occasion see the prosecution or the defense or member of law enforcement giving an interview to the public, to update the public on the status of the case, even press conferences. This has never happened in this case because of this non-dissemination order. So now we see that on top of all of the above, the court has now entered an order that further documents that were to have been filed to prepare this matter for trial, that never were required to be filed under seal, have been filed under seal. I'm speaking of the jury instructions. These are documents in their final form, which will be used by the court to instruct this future jury, who will begin to be selected at voir dire in approximately 98 days on July 30th, 2025, on the law. Judge Hippler is the trier of the law. Amongst his other duties, he will be instructing that future jury who will be making the decision as to ultimately if Mr. Kohberger is guilty or not guilty of the 5 first-degree felonies he is charged with, on what the law says, on such matters as perhaps what reasonable doubt is. Here is a sample jury instruction from the Idaho Supreme Court. There is no indication that this jury instruction will be used, but it is a prediction, in my opinion, that one of the sides will ask the court to instruct the jury on what reasonable doubt is, because their role is to determine guilt or not guilty based on the prosecution's standard of producing sufficient evidence to persuade that jury to convict Mr. Kohberger beyond any reasonable doubt. So with that in mind, we look at the court's order of October 9th, 2024. This is the pretrial and trial order. And in this document, the court has stated certain specific items to ready the matter for trial needed to be filed under seal. We see here filings pertinent to proposed jury questionnaires were to be filed under seal. Matters related to trial exhibits were to be filed under seal. The parties' lay witness lists were to be filed under seal. There is nothing here stating that, number one, the proposed jury instructions and any agreements, which is what a stipulation is, or objections to the other side's jury instructions were to be filed under seal. However, both sides filed their proposed jury instructions under seal. We now see another order entered on motion by one of the parties, this is the state, to seal the state's response to the defendant's proposed jury instructions. You can find this on the docket, the motion first that led to this order. It is dated April 20th, 2025. It states, comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code 74124B, that's a statute, for an order sealing the state's response to the defendant's proposed jury instructions based on the fact that the defendant's filings have been submitted under seal. The state leaves the ultimate determination to the court's direction. Respectfully submitted this 18th day of April 2025, and this is signed by Joshua D. Hurwitz, Special Deputy Prosecuting Attorney. Now, if we go to April 20th, 2025 on the docket, we will see an order granting this relief. This is order sealing state's response to defendant's proposed jury instructions, and it says here, based on the state's motion to seal the state's response to defendant's proposed jury instructions filed, the court does hereby confirm and order that it is exempt from disclosure and sealed pursuant to Idaho Court Administrative Rule 32G1 and I for the reasons stated in the motion. So ordered, April 21st, 2025. Signed, Stephen J. Hippler, District Judge. So therefore, every single jury instruction and now every single objection to jury instructions that have been filed by the state are all under seal. The public has no knowledge of what any of them say. And the rhetorical question that I'm asking is it possible that every single proposed jury instruction, such as an instruction on reasonable doubt if it was filed, is required to be sealed? Or should that have been disclosed to the public in part, some of them, particularly since the court had originally ordered that none of the jury instructions, none of these stipulations, and none of the objections should be filed under seal? What are your thoughts on this matter? All of your opinions, all of your thoughts are appreciated. This will now conclude this episode of the Indie Zone. My name's Kathy. Thanks for joining us here today.